Thank you, Elle, and welcome everyone. Glad you're able to join us here for this very important topic. I think we can all agree that having an unbiased jury is essential to any trial, especially when you're trying cases for immigrant victims of domestic violence and sexual assault. And we hope that today we can give you some strategies that you could develop to ensure that the jurors that are selected do not bear any prejudice against the victim and can understand the underlying dynamics of the case. With that, I'm Rocio Molina. I'm the Deputy Director at the National Immigrant Women's Advocacy Project. We're a technical assistance provider. And what that basically means is we're here to support you in your work and connect you with experts. And we hope that that you're able to gain some strategies and insights from the session that we have here today. I wanted to introduce our panel of experts, and I'll hand it over to Jane Anderson so she can tell you about her expertise.
Hello, everyone. Wonderful to be with you today to talk about jury selection because it can really make or break your case. I'm an attorney advisor with Equitas. We're a nonprofit funded to provide training and technical assistance to prosecutors and allied professionals that work with domestic violence, stalking, sexual assault, and human trafficking. We're really proud to partner with NUOP on a lot of their projects, including really specific prosecution-focused resources. And we invite you always to reach out if we can help you in any way. Thanks.
Elliot, Casey, I'll hand it over to you so you can share with us.
Hey, Rocio, thank you so much. I appreciate it. And thank you, Jane. So my name is Elliot Casey. I am a staff attorney with the Virginia Commonwealth Attorneys Services Council. We're the state agency that trains prosecutors in Virginia. And I spent about 15 years as a prosecutor in state and federal court. Most of my time was spent, 99% of my time was spent trying cases, everything from suspended driver's license up to homicide and everything in between. In both the city of Alexandria and also down in Albemarle County, which is the area around Charlottesville, here in Virginia. And I have been training with NEWAP for, I guess, about the last 4 or 5 years. Ro, I can't remember exactly when I started, but that's, yeah. I started with Charlotte, I think. Charlotte and I trained together.
All right. I guess that's my segue to introduce myself. I'm Charlotte Jackson. I'm the Domestic Violence and Sexual Assault Resource Prosecutor for the Prosecuting Attorneys Council of Georgia. And like Elliot, I work for the state agency or a state agency that provides training and technical assistance to prosecutors. I have been a prosecutor for over 30 years. I spent most of my career at the Fulton County District Attorney's Office in Atlanta, where in addition to prosecuting domestic violence and sexual assault crimes, I did major felonies, homicides, etc., and also spent a great deal of time working as a community prosecutor, working on those kinds of crime initiatives. And now I spend time traveling around Georgia and also assisting other offices throughout the country with their domestic violence and sexual assault training. And I love having part of that, being part of the NEWAP team and providing this important training for you.
Thank you, Charlotte. I think with the expertise we have in here, hopefully we can be able to better support your work. Here we just wanted to thank OVW, the Office of Violence Against Women. The opinions, findings, conclusions, and recommendations that we discuss here do not necessarily reflect the views of the Office of Violence Against Women. So let's see where you guys are from. Share your city, your state. If you want to share your weather, go ahead and put that up in the chat. I'm in El Paso, Texas, and it's sunny and hot like it always is. All right. And then one more question once you guys get that in there. I'll get everyone a chance to put that in the chat. Feel free to use that to ask questions and interact with our panel of experts and each other. So let's see who's on the call right now. So this is an A, B, C, D, E question, but if you want to type the whole word, it might be easier for us to do the quick tally of that. A, if you're a law enforcement officer. B, if you're a prosecutor. C, system-based advocate. D, victim advocate working in an NGO. And then E, if you're other. And if you're other, tell us what other you work at. Adult protective, child protective services, and the court system. Great. So it looks like we have all professionals from all over.
Yeah, it does. A good mix of folks on the call. And I know, we all struggle with our Zoom sometimes and to be as interactive as possible, but we're going to be monitoring this chat. If you make sure that it says everyone with who you're sending the messages to, we'll monitor that. There's also a Q&A function, and we'll be monitoring that as well as we go through.
So let's dive right in.
Perfect. So we'll start with sort of, just the basics of what is voir dire, depending on where you're at. Maybe it's voir dire or jury selection. And essentially the courts have said, there's a suitable inquiry is permissible in order to ascertain whether the jury has any bias, opinion, or prejudice that's going to affect our ability to have a fair and a fair trial, right? Because the government, the prosecution has a right to a fair trial, as does the defense. And so we need to be making sure that we conduct this inquiry. Of course, it's under the supervision of the court. And that's kind of going to flow into our next slide, which is a little caveat, because honestly, jury selection is one of the hardest things to train on a national basis because the rules vary so widely. I remember working in Miami prosecuting cases, and not only was it different from courtroom to courtroom, sometimes even with the same judge, it was different from day to day or case type to case type. So we're here as a resource for any follow-up questions that you have. If you're working in jurisdictions where, you're limited to questionnaires, or whether you're, asking the judge to ask questions on your behalf, we're going to kind of try to cover a lot of that, but we understand that not everything we talk about might be something you can personally immediately apply, but usually there's a way to sort of, be a little creative and make sure that we're doing our jobs, which is to ensure that the victims in our cases have their stories listened to by folks that don't have any unfair biases or prejudice. So with that said, prior to even, talking about jury selection, you're really incumbent upon you as the prosecutors, and this is a great thing to do in a collaborative way with your victim service providers, with your law enforcement, really take a look and analyze your case. Because when it comes to this question of immigration status of your victim, it may be something that your initial reaction is, hey, I don't want the jury to hear this. I'm going to try to keep out the fact that the victim in this case was undocumented or has applied for a U visa. I want to just keep it all out. Well, the reality is that that's not going to be possible in a lot of cases, especially when the victim in the case has asked for a U visa, a T visa, continued presence, even if not actually even signed yet. That inquiry is something that probably would be admissible in a lot of your cases. So then the idea is, okay, let's look at our case and figure out and strategize how we're going to talk about it, because we know we have to talk about it. How are we going to talk about it? So oftentimes we can kind of turn that around and make it a benefit to our case when we talk about it in ways that can strengthen this idea of, hey, this perpetrator, this offender, this defendant that's sitting here, they purposefully calculatedly, they picked this victim for the exact reason that this victim doesn't have immigration status, and therefore I can control them, I can exploit them, I can get away with all of this because the likelihood that this person is going to, go to the police or participate in a prosecution is so low. So we need to be able to think about, can we talk about it that way, almost like a predator prey? We can start having those conversations. If we're going to talk about that way in trial, then we need to figure out, okay, let's maybe think about how we're going to integrate that into our jury selection. The other time it's going to come up is whether that immigration status was actually part and parcel of the criminal act itself. So they selected the victim, but then whatever the crime is, whether it be, those power and control tactics in a domestic violence case, or whether it be the way that they used force, fraud, and coercion in a trafficking case, those threats, that was all part of an immigration-related threat, an immigration-related sort of power and control dynamic. So it could be part and parcel of the criminal act itself. And then, of course, the last piece where we might want to talk about it, we might talk about it in all three of these, is does it help explain maybe the victim's behavior, whether that be a delayed disclosure? We know that happens in a lot of our cases for many reasons. One of them might be related to the immigration status. The fact that the victim maybe wasn't participatory and then now is, or whether previous cases were dropped. It might explain all of that as well. So we've got to first do our analysis and then come up with our plan of action to do the actual jury selection. So goals of jury selection, and these are true in every case. Of course, we're going to have Charlotte and Elliot are going to dive a little bit deeper into some of these specifically, but we should always be thinking of all of these goals when strategizing our voir dire, our jury selection plan. Everything from sort of, can we start doing some education as early as our jury selection? Can we start making sure our jurors are going to be listening with open ears and have empathy for our victim? And then, of course, we have the real goals and challenges about, uncovering those biases we want to make sure our jurors don't have when they're listening. So let's dive in a little bit deeper. Charlotte.
Okay, so for me, voir dire is like going to a restaurant. You walk in the door, you think you see, this is a hyped restaurant, everyone's been talking about it. Voir dire is that first impression, that first appetizer that you get, that first service from the waiter that tells you, when you taste that appetizer, when you see how that appetizer is laid out on that plate, what this meal is going to be about, and if it's going to be good or not. That if you start off with a bad experience with that appetizer and that waiter, no matter what they serve you, you're not going to be happy. If you are someone that can be more open, you might be willing to stick with it till the end, and hopefully the meal will get better. And then you have people that are just going to shut down. I might be one of those shut down people. But anyway, so think about that when you're thinking about voir dire. This is letting the jury know what your case is about, what you were about, what you're going to serve them. And so part of that is educating your jury panel about the case. If you wait until you start actually presenting evidence, if they've had a bad experience with the appetizer, they're not going to be buying what you're selling. But this is a great opportunity for you to educate your jury about special issues that you may have. And so we know in intimate partner violence cases, as well as in cases involving immigrants who've been victims of intimate partner violence, there's just going to be some issues that come up, or there's going to be things that your jurors aren't going to understand that might be you want to talk with your jury about. And so this is your opportunity to educate your jury about these concepts. And so the way that you want to do it, first of all, is helping your jurors to understand that everyone has bias. Bias isn't necessarily a wrong thing. It's human nature. It's how the bias is applied. The other thing that you want to think about is specific examples from your case. Did you have an immigrant victim who did not initially cooperate with law enforcement? Is that something about your case that needs to be explained? Did you have a victim who may have recanted or changed their story? Is that something that you're going to have to explain? So think about those things that the defense is going to make a big deal about, that you can just take the wind out of their sails by educating your jury about it, so that by the time they hear that evidence, it's old news, nothing to see here. They can move on to the great dessert that you're going to serve them with the closing argument. So the ways that I would do that is, first of all, I would reassure the jury that things are normal by reassuring them that bias is okay, but also introducing them to concepts that everyone has in common. That, for example, talking about intimate partner violence in front of 1 million people that you don't know isn't so easy for anyone. And so you want to use those kinds of examples or formulate questions around that to help the jury to connect, not necessarily just to the victimization that your victim or survivor may have experienced, but just the things that all people have in common. In my experience, I have noticed that sometimes victims, particularly a lot of people don't report intimate partner violence. And so if you spend a lot of time trying to get your jurors to connect with your victim, the victimization part of it, they're not really necessarily going to go there. But if you connect them to those things that everyone has in common, for example, wanting things to be made right that were made wrong, jurors' willingness to help people who have been in trouble, jurors' willingness to take down a bully, those are the kinds of feelings, those commonalities that you can use to help your jurors to connect to your victims. And so once you identify those issues, you want to formulate questions about those behaviors. So, for example, you might say, do you know of, or has any of your friends or family members ever been a victim of domestic violence and did not report it? So that kind of gives the jury the idea, as people answer the questions, that this is much more common, because usually when people have experiences, they think they're the only ones. The other thing that other topics that we want to talk about are some of the ones that we have up here on the slide, but you want to formulate the facts of the question into your question. And so you want to talk about victims recanting behavior. You want to ask your question to incorporate the type of behavior that your victim is demonstrating, so the jury will be used to hearing it. Managing expectations. You want to, jurors are going to have certain expectations about the way that a crime happens and the way that victims are supposed to act. And so the other thing that you want to do in our second building block of voir dire is to help our victims to understand, help our jurors to understand that everyone is going to react differently. And this will help to kind of open your jurors' minds to understand why it is, our victims, which is very typical to us, may not report crimes, that they may be undocumented, that they may themselves have engaged in criminal behavior. And you want to think about, first of all, why these expectations need to be managed. Incorporate into these questions the standards in your community. Some communities, sometimes in urban communities, people have a lot of exposure to people with lots of different lifestyles. They may not necessarily have an issue with a victim who has previously committed a crime or may be undocumented. In some smaller areas where people tend to be less exposed to people of different cultures, this is something that may have to be managed. So tell them about things that they might hear. You may say to your jurors, you may hear that our victim was here, that our victim was undocumented at the time of the crime. or that they may have been engaged in criminal behavior. Is there anyone that has a problem with that? Or would this, or could this, is another way to phrase that question, would this or could this keep you from being fair and impartial in this case? Or, for example, another example of managing expectations might be, you may hear evidence the defendant may have used not violence, but threats or coercion, threats about deporting the victim to get them to comply with their will. Is there anyone that would not be able to listen to this type of evidence? Finally, you want to instill empathy, and this kind of connects back to what I was talking with you about. The empathy people feel, sometimes it doesn't necessarily come by having that common experience, but maybe having those common characteristics. And so in a case involving intimate partner violence, you might want to ask questions around, help the jury to know a little bit more about your victim, that your victim is a mother, that your victim has children that she cares about, that your victim had to make certain choices in staying with the abuser, or fearing leaving the abuser because she was afraid of losing custody or losing access to her children. These vulnerabilities are common things that parents feel, people in society feel. These help to have jurors connect to your victim, and that releases those empathetic feelings. Try to focus more on justice for all, the purpose of the criminal justice system. People approach our court system, which, right now, the perception of our court system is under attack because people feel that justice may not be there for all. So this is a jury's opportunity to see that the justice system does what it's supposed to do, which is to listen to both facts, give both parties a fair shake, and make a decision based on the evidence. And then find out what things jurors may have in common with each other and with the victim, and use their stories. And so if they, perhaps someone is using their story as having to care for children, or having to care, for example, if you had having to care for a child and having to leave court early because they want to make sure their child is safe getting on the school bus. Keeping your children safe is something every parent wants to do. That is something that jurors would have in common, and you can use compare that juror story to your victim's story to help to instill empathy.
So, one of the mythologies I think about voir dire is that the goal is to eliminate anybody who has any knowledge that is relevant to the case, right? And that can't be what voir dire is about. Just this past summer, we invited the former DA from Aurora, Colorado, to come talk to our prosecutors, and that was a shooting that was international news. They called in 10,000, almost 10,000 potential jurors, and sent out juror questionnaires to almost 10,000 people. So, you can imagine when they're picking a jury in that case, neither side wants somebody who's never ever heard about the shooting ever, right? It's not an achievable goal. It's not a reasonable goal. And that's not the kind of person that you want, right? What you want is to have somebody who is not biased. And ultimately in that case, for example, it was interesting. I mean, one of the jurors that they picked was a survivor of the Columbine shooting. And they determined he could be fair and in other circumstances of the case, despite having been childhood friends with the shooters in that case, and a prom date of one of the victims. What you're trying to identify, what you're trying to weed out, is people who are biased in a way that they cannot judge your case based on the facts that they hear in the courtroom and the law as they're instructed by the judge. And so, if you have a case, for example, involving people who speak Spanish, it's okay to have jurors on the jury who speak Spanish themselves. What your role is to make sure that their knowledge of Spanish, such as it is, right, doesn't bias them in some way, make them unable to judge the case properly, right? So what's your goal in voir dire? To make sure that they either speak the same Spanish that your victim does, or at least that they understand that there are differences in the Spanish language depending on where you come from, right? So delincuente means delinquent in Puerto Rico, but it means some places it means criminal, for example, in some places in Mexico, right? The verb cancelar can mean to cancel, or it can mean to pay off. That's a huge difference, right? If you've got a case involving a debt or enforcement of a debt. And equally, I think there's a huge amount of mythology about what the immigration system is and what it means and what immigration law is. For my lawyers out there, or for my people out there who work in victim advocacy, you probably hear all sorts of stories about what versions of what immigration law currently says. And I would bet that 90% of the people out there who say, oh, under immigration law, this is the law, this is the rule, are wrong about that, right? Having learned now what I know that most people's understanding of what the law is not correct or not complete. So your job in voir dire then is to confront that, to bring that out, and then to either dispel that misunderstanding or at least get people to a point where they're willing to judge the case that they're about to hear on the facts that you're going to give them and the law as the judge is going to instruct them, right? That's always a proper goal, to identify something that they don't understand properly and to either eliminate that bias, or if you can't eliminate the bias, eliminate that juror, right? Eliminate them for cause. That's what your goal is in all these cases, right? So when we're talking about uncovering biases, how do you go about doing that? Well, the first thing that you want to try to do is you want to try to go out and harness social media, right? Social media is still a wonderful tool. And it is perfectly lawful for you to do that. Even if you're an attorney, to do social media research on jurors is fine. In almost every state that's considered this, and the ABA has a model opinion on this, it's number 466 if you're looking these up. It advises that since it's the provider, not the lawyer, making the contact, right? It's Facebook collecting and putting out this information. It's not an ethical issue for you to go out passively and just look at what's on the internet left by your potential jurors on Twitter, on Facebook, or whatever. And as long as you're not communicating directly with the juror, right, which obviously is prohibited under Rule 3.5, which prohibits any kind of direct or indirect communication with a juror, right, you're okay. Now, if you send a friend request to the juror, you're going to have a problem, right? And keep in mind, by the way, that obviously is true for Facebook, but if I'm looking up somebody on LinkedIn, LinkedIn will notify my juror that I've looked at them, and that may create a problem for you. Maybe it's not an ethical problem, but your juror is going to want to know why you're spying on them. They're going to see, oh, that you looked at them. So keep that in mind as well. And Charlotte points out they use social media research in every case, right? That's absolutely appropriate. Now, keep in mind that the rules that govern you govern your paralegals as well. So your paralegals are permitted to do this, but if you're asking somebody who's a victim advocate or a paralegal or somebody on your team to do this social media research for you, you really want to make sure they understand the rules, right? Rule 8.4 prohibits an attorney from violating that rule, violating the ethical rules through others, right? For example, in South Carolina, there was a case called In re Myers, where a prosecutor had a lay member of his team, somebody who was not an attorney, call a member of the veneer to try to talk to them to get some information. And you cannot avoid the prohibitions on contact with jurors by simply sending somebody who's not a lawyer in your place. Rule 5.3 warns us that a lawyer is responsible for the conduct of people that he or she supervises. If that conduct is a violation of the rules of professional conduct for the lawyer, it's also a violation for the lawyer's team members to do that as well. You cannot act through another to do what you're prohibited from doing. But that having been said, again, by all means, harness what's out there. There's a lot of great aggregation tools. Obviously, Google is out there, right? Bing is out there. But people search PIPL. PIPL is a great search. Yippee. There are search engines. You can go out there to search for people. You can look for specific usernames, handles, aliases. If somebody's using a Twitter handle or Twitter alias, it's likely to be that maybe their Instagram alias or their alias on something else. So again, these are great tools to find out information about people. And we're at the point now where most Americans have some kind of social media presence. So that's a great tool as well. So that's a great way to get information. But again, if you're standing there in front of the jury for the first time, and like Charlotte said, you got that first impression, that opportunity to make that first impression. That's where you want to establish trust, right? You want to establish trust with the jurors. And there are several different ways I think that we can do this effectively. Number one is you always want to be truthful about the law, even when it hurts you. You always want to be truthful and honest about the facts, even when the facts hurt you. Never hide bad facts. Just yesterday, a prosecutor called me up and was asking me about a situation that she had with a police officer their whole role was transporting a piece of evidence from point A to point B. They took the evidence, put it in the trunk of their car, drove it to somewhere else. Unfortunately, it turns out that officer was terminated due to some untruthful conduct. That officer is being prosecuted right now for that conduct. And so the question is, how do you deal with it? And the first answer always for me is you own it. You get there in front of the jury and you say, hey, ladies and gentlemen of the jury, this is what the facts are going to show. You don't make a big deal about it. It doesn't become the centerpiece of your case, but you got to own it, right? People expect lawyers to be tricky. And trust may be a real issue in your community. Right? But people in general, even in a community where there's not a lot of trust in law enforcement, not a lot of trust in prosecutors, not a lot of trust in the legal system, in general, people will trust an individual person who listens to them, who has authority but doesn't abuse it, and who is truthful, upfront, and honest with them, answers questions clearly, and speaks plainly. Right. So my view when I'm in front of a jury in voir dire is, ladies and gentlemen, welcome to my courtroom. This is my courtroom. I own all this. This space belongs to me. I am, going to step aside for a few moments and let the defense attorney talk when I've decided it's okay. And the judge from time to time will make calls about issues. But basically, I'm not saying this out loud, by the way, to them. Never tell the jury this. But the attitude that I'm conveying, right, is I'm a gracious host, right? This is my courtroom. I run this place, but I'm going to be gracious. I'm not going to be a jerk about this. And if you think about the judges that you've seen before, right, the judges who have authority, who project authority, are ones who are quiet but carry dignity and authority with them. The judges who are clearly not in control and who no one trusts and who everyone kind of snickers about in the background are the ones who are strident and screaming from the bench and angry and yelling at people and pointing fingers and being accusatory. That gives you nothing, right? You'll never establish trust that way. And so what I guess the point then is that trust really comes from leadership, right? You are there as a representative of this system. So it's important, it's crucial really, that you believe in the process and you believe in the system. Jurors will tell if you don't. If you don't believe in what you're doing, they're going to see through whatever words you put in front of them. Now, don't belabor it, but don't patronize them either. I personally never thank a jury. I never thank the jury before the trial, after the trial. I don't thank them because it's their job. It's their duty. It's their solemn duty to be there just like everybody else. I don't thank the defendant for showing up to trial, and I'm not going to thank a juror either. But when I believe in that process, I believe then too, if you have an issue, a specific issue here, for example, with a victim who's getting a U visa or a T visa, I believe in that. Right? People hate the idea, and jurors are going to naturally distrust the idea of somebody getting something in exchange for their testimony. Right? But so you confront that, own it, and hit it right up front and uncover that bias, expose that bias, and either dispel it or dismiss that juror, right? Ask them, would you refuse to believe somebody because they had their medical bills paid for by insurance? Would you refuse to believe somebody because the damage to their home was paid for by their homeowner's policy? Would you refuse to believe somebody if they were a witness to a crime and they called police, but they got a Crime Stoppers reward afterwards? Right? It's ridiculous. I mean, you wouldn't refuse to believe that. And I'll be perfectly honest with you. Before I joined NEWAP and before I started doing this, I really didn't like the U visa and T visa system because for me, I felt like, you're interfering with my case. You're giving my victims in front of a jury. It's going to create a situation where the jury is not going to trust them. They're going to think that they have a reason to lie, a reason to fabricate. It's going to ruin their credibility in a case that's already hard enough to prosecute. But the thing that I realized was, I was a drug prosecutor. I was making deals with people all the time in exchange for testimony. Every witness that I had who was a cooperating witness received something in exchange for their cooperation. And I was used to owning that in front of a jury. Of course, no one's going to come to court, trial otherwise. So, own that fact, but understand and make sure that and help the jury understand, because you're trying to uncover that bias. This isn't a situation where somebody's being rewarded, right? As Jane said, I think so eloquently before, this is a situation you want to make them understand. What we're doing is we're protecting our victims and taking a weapon away from an abuser. So instead of asking the juror, would you object to or would you have trouble believing a victim who received something in exchange, right? Frame it is in the terms that it really is, taking away a weapon. Ask the juror, if you learned that the victim in this case, came forward because she could not live on her own, she could not escape from the defendant, she did not have legal status in the United States, would you refuse to listen to that victim if the government told her she could be safe from removal from this country while this case was pending, even if she left the defendant, right? As long as she was willing to come forward, right? Do you think that the government shouldn't be able to create a safe place for crime victims to flee if they're being exploited due to their lack of immigration status, right? That's what you want to do. You want to, again, believe in that, understand the system, understand why it's there, believe in it, and then get the jurors to confront their biases. And if they're willing to say, you know what, okay, I'm willing to accept that a victim may, maybe the only reason that she is going to be able to come forward without fearful of losing her children or indeed being removed from the country is given some kind of temporary protection. But again, you want to confront that. And some jurors are not going to be willing to accept that. You just need to be willing to find that. I did a case in federal court a number of years ago where it was a drug case, but I got up in front of in voir dire and said, "Hey, anybody here in this veneer panel, anybody here have a problem with the U.S. drug laws?" So I got 50, 60 people in the room. Anybody here have a problem with the drug laws? I get crickets, no response, nothing. Nobody has any response. Like, what? Come on, you guys are liars. You're telling me nobody in this room has a problem with the drug laws in the United States. I have a problem with the drug laws in the United States. Come on, you people are lying to me. Whatever. Okay, fine. So nobody has a response. I sit down. Defense counsel stands up and says, "Hey, look, you're going to hear that my client was not in the United States lawfully. It was part of the elements, one of the offenses we charged him with. So he's not in the United States lawfully. Does anybody have a problem with," he asks, "the fact that my client is entitled to all the constitutional rights that any citizen would be entitled to, trial by jury and so on, even though he's not here in the lawfully here in the United States?" And fully a dozen people raised their hands. And one guy wouldn't let it go. I mean, he just said, "I just don't understand why we're having a trial for this guy." And the judge had to call him. I mean, the judge got really angry with this guy and ultimately threw him out of the courtroom, threw the veneer panel out of the courtroom, because he just was like, "I don't know why we give rights to anybody who's here on the United States unlawfully." And the judge literally said, "Get out of my courtroom now, leave." And he kind of looked at me like, "What am I supposed to do?" And I said, "You should leave right now before something that really bad happens to you. So do not pass go, run out of this courtroom and leave this courtroom. Don't come back." So he was gone, right? But again, that guy, he wasn't going to give up that bias. That was never going to happen, but we needed to confront it, right? Your touchstone is that adequate voir dire. The goal is to remove prospective jurors who are not going to be able to impartially follow the court's instructions and evaluate the evidence, right? That's what your goal is. And, you can pay for a $30,000 jury consultant. In my view, all that stuff is voodoo. I mean, you have to go with your gut. And sometimes you got to leave somebody on that you didn't want to leave on. But it's all kind of a hit or miss sometimes. You have to go with your gut. I left a lady on one time who had years before had a huge conflict with my lead detective in a homicide case. And they knew each other, absolutely knew each other. And she did not like him, didn't want to talk to him, hated him. They had a really bad confrontation. I left her on. She became the foreperson. They convicted the guy and gave him like 56 years. We've left Catholic priests on murder juries before. We left Thurgood Marshall Jr. on a jury one time. There's no rules for this stuff. You have to go with your gut. But again, that's sort of the touchstone. Jane, do you want to? I think you do.
Yeah, I think we just kind of bookmark all that really great advice that Charla and Elliot shared with this quote, because some of you might be sitting there going, I would never be able to ask all of these questions. I don't have enough time with my jurors. And this quote is from a US Supreme Court case that says, there really needs to be an adequate voir dire opportunity. And so if you're asking, your judge and you're trying to say maybe expand your ability to ask these types of questions, this would really be a great case to cite, and perhaps even back this up with some research, some case law that talks about how immigration can be an inflammatory device used by the defense, and as well as something that that jurors are expected to have perhaps some questions about, right? And with the U visa, I love, Elliot sharing, like, I didn't like this, right? Because it's something that is so widely misunderstood. And so as a prosecutor, you need to understand the U visa, talk to your victim advocates, those folks that are maybe more comfortable with like how this process works, what it is not, because you're going to have to, strategize how it's going to be brought up in your case, but B, you're going to have to probably educate your judge about it as well. And so by letting your judge know, like, listen, there's a lot of misconceptions about this. I need this adequate opportunity to ask the questions, is going to be important. And then the other thing that I always like to talk about when we talk about voir dire is to this development of an offender-focused theme. You might not be thinking, hey, I don't need to use a theme in my voir dire, but if you've got a theme, and I really encourage you guys to do this because it's incredibly effective. You can start thinking about how to introduce it through your jury selection and voir dire. I've got some folks here. I'm wondering what is the most famous theme out there? And I don't know, maybe I'm aging myself, but there was a very effective theme that was used by defense counsel in a very high profile case. And it was incredibly, incredibly effective. So if you guys want to guess what theme I'm talking about in the chat, please go ahead. But the idea is you want something kind of that encapsulates your cases, your case facts really succinctly, but also starts illustrating the dynamics of your case. So obviously, Crystal wins. If it don't fit, you must acquit, right? And it's powerful. And if you start using a theme and you sort of integrate it through your entire case, you close with it, it's going to also be resonating in your jurors' ears when they're going back and looking at the evidence, reviewing the testimony, and hopefully they do it through the lens that you want them to do it through, right? So preying on the most vulnerable. That could be a really effective theme in a case where an offender, identified a victim because of this vulnerability being a lack of immigration status or uncertain immigration status. So power over the powerless. These are all really great ones. I know some prosecutors that use the American dream became a nightmare mostly in a trafficking context, and knew there was nowhere for them to turn. That could be a really great one if you're talking about a case where a victim didn't initially seek out help because they didn't have anyone to turn to. They didn't understand the systems. They didn't think that the system would work for them. That can also be really powerful because then you get the jurors on your side of like, I'm going to be the one that is going to sort of stand up for this victim. And this shouldn't have happened in our country. Everyone should have equal access to law enforcement and no one should be victimized. So you can really start integrating those into your voir dire as well. And it's kind of a fun exercise. I love working with my law enforcement to come up with something fun, and it's a little creative minds at work and can build your relationships and your multidisciplinary teams as well.
Thanks for that, Jane and Elliot and Charla. When people registered, we asked them to submit questions, and I've selected a few that we did some slides, and we were going to just shoot them out to you. And everyone else, as you're listening or as the presentation went on, maybe you had a question of your own, so feel free to add it in the chat. But we're going to go ahead and start off with this first set of questions. And this one is to Elliot. In more conservative jurisdictions, how can you advocate to the judge to ask more questions or to include more in the questionnaire?
Yeah. So, unfortunately, I mean, in a lot of ways, this is baby steps. And what, Jane mentioned before how voir dire was different in her jurisdiction, courtroom to courtroom, and sometimes different from trial to trial with the same judge. And this is something that was true for us in Virginia. And, I saw Mary Kate pop up here before. I'm curious what they do in Chesterfield. I think if it's changed, our statute in Virginia changed last year because ultimately they did want individual lawyers to be allowed to conduct voir dire of jurors and not just have the judge do it. In Virginia, there was a real range. In some jurisdictions, you had wide latitude. And in some jurisdictions, the judge says, I will ask the questions and you will sit there quietly. And then you make your decisions based on the questions that I ask. Some judges would listen and ask questions that were submitted, and some judges wouldn't. And so we had a real range here in Virginia. I think this education process is also a long-term education process with your judges. The federal trial that I had was with a judge who was very senior. He was getting ready to retire, but the experience of having such blatant prejudice brought out in the middle of a trial that, somebody was willing to stand up in a courtroom openly in a federal courtroom and say, people who are not here lawfully have no rights. It was a real wake-up call for that judge. I think he'd never seen anything so overt before. And so again, when you're focusing on with your judge, look, judge, I am trying to bring out biases that will prevent somebody from being able to decide this case based on the facts that they hear in this courtroom and the law as you instruct it. Your ability to identify the existence of biases that prevent people from making those kinds of decisions, from deciding the case based on the facts and based on the law, to a judge before voir dire begins will help you with your judge who otherwise won't let you ask these questions. And so you're going to have to figure out a way to educate the judge about that. And there's different ways to do that. I mean, one is to, file pretrial motions. One is, unfortunately, and this is how it's happened to me in several cases, is as I do lose cases, lost a lot of cases, and go out and interview jurors and talk to jurors, and then afterwards let the judge know, hey, look, I talked to the jurors, and just to let you know, this is what they said. This is what they conveyed to me. This is what they told me. And I've had judges, admit to me later, I denied this motion or refused to let you go into this issue. And now, having seen what happened in this one case, I've now learned that I need to let it happen in the next case. The other thing is your goal here is either to strike people for cause or rehabilitate people. And to be honest with you, the striking people for cause thing, if you're trying to get people identified to have them struck, the judge is not going to be on your side about that. Most judges want people to be rehabilitated, right? Because they want a jury to be picked. They don't want to whittle away on people and to the point where they can't seat a jury, especially now in COVID when it's difficult enough to get people to show up to your courthouse in the first place. So when you're framing questions, if you're submitting to the judge or trying to get them approved by your judge, you always want to try to frame them as a rehabilitation question, right? So instead of saying, does anybody here, think you wouldn't be able to decide the case based on blah, 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 try think of a question like, do you understand that a U visa is not citizenship? It's simply temporary protection from deportation. And it doesn't even give the victim the right to work at this point, right? So that, do you understand that even when this case is over, no matter how it turns out, it's for the Department of Homeland Security to decide what happens to the victim. And they do their own investigations, that what you do in this case will not change the decision of Homeland Security as to whether or not this person is allowed to stay in the country or has to leave, right? So there I'm framing my question as a rehabilitation question, right? You may walk in here with a very distorted understanding of immigration law, one that would prevent you from deciding this case based on the facts that you hear in the courtroom and the laws you're instructed by the judge. But I'm going to fix that with a question. I'm going to try to rehabilitate you so that you will be able to stay on this jury and decide this case. And that's the point of this question, right? Is to do that. But in the process of doing that, obviously, again, you're educating the jury, right? Which is what, Charlotte and Jane are talking about here, is trying to educate the jury so that they will decide your case fairly. But But I think if you're fighting with a judge about trying to get, more strikes for cause, you're on a losing ground. If you're trying to help your judge rehabilitate jurors and keep them from getting struck and educate them so that they can stay on the panel, then at least, you've got a chance of keeping the judge on your side. It's a long process. It's not going to happen over the course of one trial. Or if it does, you're a better lawyer than I am. Oh, and Mary Kate's got an answer. She says, in Chesterfield, attorneys ask questions of the veneer. I believe we have a pretty latitude to ask questions. Yeah, that's what I remember Melissa Hoy telling me too. So thanks, Mary Kate. Appreciate it.
And then the resources and materials that we have in the webpage that I shared earlier, I'll kind of paste it right now after. But we have 3 sample questions that you all could download and look at them. And we also can provide support if you have questions on how to frame a question, or if you want to do it in the style, like Elliot said, rehabilitation. That's something that we can do through our technical assistance. Let's go on to the next one. Charla, how might you use the veneer members to educate about domestic violence, sexual violence, or stalking?
The best way that I have used, that I would suggest doing it, is using storytelling. And essentially, when you are asking a juror a question, for example, has anyone ever been a victim of DV, sexual assault, or stalking? When that person answers yes, and you go back and you do the individual questioning, the questions that you ask that person and their relating of their experience with domestic violence or sexual assault helps you to understand their bias or their suitability to serve as jurors on that panel, but also helps jurors to right there in front of them experience or hear from a survivor. I had a recent domestic violence murder trial where I actually had a man on my panel, on my jury panel, who was a victim, a survivor of domestic violence, and he was talking about his reasons for not reporting a crime, reporting the abuse that he was experiencing, and it actually helped. My victim in my murder case had not reported incidents of domestic violence, and having him tell his story actually helped my jurors to be more accepting or to understand the reasons why my victim would not have reported the crimes against her. And so just, get them talking, and that helps them. They educate each other with your guidance, and that helps you to have a better outcome. That's my answer.
I just love hearing from Elliot and Charlotte, because you can tell that they are both incredibly effective prosecutors and attorneys, but they come with different styles, right? And I think it's important when you're doing jury selection. I know I would watch others, that would be my favorite part to watch if I had time to go see another trial, is watch jury selection and try to get these tips and practices. And what I learned was that you can't mimic someone else. You really have to be you, and you have to figure out what your style is. And if you try to do something that's not your style, not your personality, you're going to immediately, they're going to figure that out. The jurors are going to see that you're not being real. And that's never going to be a good thing. So try to figure out what is the best version of you conducting jury selection, right? So maybe it is that really storytelling style that Charla, I can only imagine, I'd love to have seen her pick that jury, that she's obviously very good at. And with Elliot, he's very specific. He's modulating every word. He's being very careful about the exact language he's using, because he's talking about some legal technicalities that if he doesn't say perfectly, it's going to blow back when the judge gives instructions later on and they don't really match up so perfectly. And I loved trying cases. I spent the last 4 years of my case of my career actively prosecuting in Miami, I did human trafficking cases. And that was a very steep learning curve for everyone, because this is back in 2010. And my trials were the first ones that were being done in Florida on a state level. You know, the feds have been doing it, but the state level, we hadn't really been doing it. And so a lot of what I had to do was this education. And what Elliot said about this incremental education of your judges is so very true, because I had to remember a judge, and he was just sort of mad that I was trying this case. He was like, I don't understand. Isn't this just a misdemeanor? Why are we, all of a sudden asking for so much time? And he heard the trial. And then the very next week, he calls me up. He goes, remember that trial? He goes, I think I have another one of these cases in my courtroom right now, and I want you to come see it. And the next time I tried a case in front of him, he gave me so much more latitude to ask these questions, because he understood that there were going to be these challenges that we were going to see, and that there were going to be these bias. So just to reiterate all that before I go into this actual question being asked of me, which is how do you introduce the U visa without being accused of pre-trying a case? This is one of my defense bar's most favorite accusation of, the prosecutors pre-trying the case. So first off, be very familiar with what the law is, what your courts say, and always happy to do some research for you guys. But I think it's something that is very rarely actually done by prosecutors. Pre-trying a case is, here are all the facts of my case. Now tell me if you're going to find this person guilty. And that's not what we're going to do. So first off, be prepared for this with your case law and your definition and what it looks like, what is pre-trying and what's not pre-trying. And then you want to introduce the U visa. If your case involves one, obviously, you want to do it in a way that discusses and kind of brings out what's the intent of the U visa, right? Why do we have the U visa? And when folks hear about it without that context, it usually gets into that area that we've talked about, which is like, oh, you guys are just conferring citizenship to someone. And so you've got to be doing that education from the very beginning. And so lots of strategies already presented that I would encourage folks to kind of play around with, because you do kind of have to play around when you're figuring out your voir dire strategies. So for me, I was always introducing this idea to the jury about I always wanted to use that language, right? Who in our community is vulnerable to certain types of crimes. And you'll usually get people, women and children. And then hopefully you can kind of have that conversation with them and say, okay, who else in our community is vulnerable? And you might get some folks that are talking about the homeless, folks that have substance use disorders, right? And so hopefully you're actually, while you're pulling this out of your jurors, you might actually be getting them to sort of describe your victim in the case, and then talk about why are these people vulnerable, right? And again, you're laying that framework, which you're going to pull through your whole case, which is the predator-prey, the vulnerable and the powerful, the vulnerable that's been spotted by this person to abuse and exploit because of that vulnerability. You're keeping that dynamic going. So then the idea is going from that conversation to why are these folks vulnerable? And then you're going to get people to saying things like, well, the police may never believe them. They don't feel maybe the police is a safe place for them to report that they're victimized. You might start getting some of that conversation going with your jurors. And then you might want to say, has anyone heard of something called the U visa? It's a tool for law enforcement and prosecutors to better identify vulnerable victims in their communities. And then you're just sort of bringing them down that lane with you. And in that case, you don't ever want to, go too far in, recounting the exact facts of your case, but anything that we just talked about, all of that should not be considered pre-trying, and you should be fine. And these are really fun phone calls that I get from prosecutors, and I'm sure Elliot and Charlotte back me up. Prosecutors calling me up and saying, I've got this trial coming down. I just want to soundboard with you how we might want to do this, because it's so individualized, it's so fact specific. But there's a lot of ways that we can start laying that foundational work so that when the fact comes out during trial, the sales are put away, the defense can no longer, plan their whole case around what they originally thought they were going to do, which was get everybody inflamed that the prosecutor was giving this victim citizenship so they would testify, So that hopefully is helpful.
So Elliot, here's one for you. What can you do if you notice that the defense is striking all potential jurors with Hispanic last names?
So one of the things that, obviously this is a bad situation, but that being said, I did, if this moment happened, it was always a little bit fun to stand up and make a Batson objection, a constitutional objection to the defendant striking these jurors, because the shock on defense counsel's face that you were making an allegation that they were doing something unconstitutional just sent them in a complete tailspin. They had no idea what to do. They had no concept that they had an obligation to follow the Constitution as well, but they do very much, because it is the juror's right to sit on a jury, and you cannot discriminate against people based on their race or national origin or gender or sex to sit on a jury. And so if the defense is trying to do that, and you can imagine why a defendant would want to do that, it is you do absolutely have the responsibility as a prosecutor to step in and protect that juror's rights under Batson, which is usually considered to be a motion you'd bring against a prosecutor and say, oh, the prosecutor's impermissibly striking jurors based on their race. But the first step in a Batson challenge to stand up is just to stand up and say, Judge, I object to these peremptory strikes that a defense counsel is being made. You don't necessarily want to do it in front of the jury. You might say, hey, Judge, can we approach? I have an objection. And you kind of have to gauge your courtroom for that. But if you're making the motion, you have to you have the burden initially to establish a prima facie case of discrimination by the other party in their exercise of their peremptory challenges. So, if you're going to make this, don't make it lightly. It really needs to be apparent. So, if you have, if you're making selection from a panel of 20 and you're trying to pick 12 jurors and each side gets 4 strikes, and you look down at the strikes and you see, like you said, Rocio, let's say there's 4 Hispanic jurors or jurors that appear to be of Hispanic origin, and the defense counsel has struck all 4 of them. Well, okay, then we've got a prima facie case. The only people they struck were Hispanic, nobody else. We've got a prima facie case at that point. If you meet that burden, then they, as the non-moving party, right, they as respondent now have to give a class neutral or race neutral reason or national origin neutral reason for why they struck each one of those jurors. So, and that's interesting, right? Because normally in a peremptory strike, the whole idea is you don't have to explain why you struck somebody, right? You strike them for whatever reason. And it might be completely random. I'd be perfectly honest with you guys. Again, my first jury, I got a Batson challenge against myself because I didn't know what to do. It was a misdemeanor. It was a trespassing case. We were picking like 7 jurors, and I didn't know how to pick a jury worth a darn. And so we got down, and I had to strike one more person. I didn't know who to strike, so I just struck the first person off the list, right? And her last name was Adams, and I'm like, great, first person. I'm striking her off the list. Well, I happened to at that point then strike the only 2 black people in my jury panel, and immediately defense counsel stood up and said, I have a Batson challenge. And I was like, oh my God, what did I just do? Like, wait, no, look, I just picked a name off. I was just picking the first person off the list. I'll pick somebody else. I'm sorry. Like I just didn't even think about it. Right. So you want to be careful, but I had to give a race neutral reason. And if I couldn't, right, then I have a problem. Now, if I give a race neutral reason or a national origin neutral reason, then the burden shifts back to, so again, if it's defense counsel has struck all 4 people, they're all Hispanic, they all have Hispanic last names, then the burden shifts back to me to demonstrate, no, even though they gave these 4 reasons, this is purposeful discrimination nevertheless, right? And don't take the reason necessarily at face value. So defense counsel says, no, I didn't strike them because they had Hispanic last names. I struck them because they lived in the neighborhood where this offense took place. And so therefore, I didn't want anybody else from the neighborhood because I'm afraid that they might, have known somebody in the case or something like that. And that's my national origin or race neutral reason. But, take a minute and look at that list and say, wait a minute, hold on a second here. There's 6 or 7 people who live in that neighborhood. And one of these people doesn't even live in that neighborhood. She lives so far, she lives on the other side of town. This reason doesn't stand up to scrutiny. And if that's the case, right, the judge can find that those strikes are pretextual. Those reasons given are pretextual. Again, remember that this is the juror's right. This is not the defendant's right. And it can be a simple strike. It might be that you only had one Hispanic person in the entire panel and defense counsel struck them. That alone can be a basis for a Batson challenge. You don't want to make the challenge lightly, but you do want to be conscious of it. So I hope that answers your question, Ro.
It sure does. Thank you for that. We do have another question, and I'm just going to translate it. And it says, would a jury member be able to use interpretation services so that to ensure that there's more diversity within the jury?
That's a really good question.
So in Miami, which this question is a perfect example of, no, the jurors would not be qualified if they could not understand English sufficiently enough, because it goes kind of with, I think it's ripe for somebody to maybe litigate, but right at that time, it also is consistent with every juror needs to be hearing the same thing. And especially if there was maybe interpretation being done for the witnesses, the jurors are also, even if they understand Spanish, they're instructed that they cannot rely on their own Spanish. They have to rely on the interpretation, and that's in English. So I think it's kind of related to that concept, but really interesting question. And I wouldn't be surprised if, okay. And so Peggy says, in New Mexico, limited English speakers are allowed to serve as long as they qualify. And I don't want to say they have to be native English speakers, because absolutely not. But they are asked about their limitations in English, and they're asked about that. So I don't know if that's the same in New Mexico and how limited that would be. And if they would be provided interpretation. I would love to hear how this might be happening across the country.
I'd also like to add on to that, if you come up with that situation, you need to be thoughtful about what your response is going to be. Because if your victim is Spanish speaking, which kind of leads into our next question, if your victim is Spanish speaking, you don't want jurors' bias from what happened to that juror being excluded to be attached to your victim. So might be something that you should expect to happen in a case like this, and be prepared to have some kind of a response, which might be bringing them up, having them talk with the interpreter, with the judge, to explain what the issue is, or having that veneer person not excused until the end of the day, so it doesn't look like they're being excluded just because they can't speak the language.
Really interesting. Peggy followed up and said that her jurors are provided language interpreters. I don't want this to overwhelm the rest of our presentation, but I'd love to follow up, Peggy, with you, because we've had so many issues with interpretation having to be almost like peer reviewed as it's happening, for one of the reasons being the nuances in dialect that Elliot mentioned up front. And so I would be curious about that. And
yeah,
yes,
in fact, Jane, that was a follow-up comment from Alessia, which was, have you had cases of native speaker jurors saying that the official court interpretation was making mistakes? Yeah, I mean, I haven't had a situation where a juror has spoken up about that, but I've had issues where we get into a huge argument in court about whether or not the interpretation was correct or not. And that's a big issue.
You guys use keep a list of certified interpreters that are supposed to follow certain standards. We do that here in Georgia. That
sounds like, Rocio, we could have a whole language access webinar on this.
Right.
Yeah, you know,
So
which brings us into the next question. We know that interpretation takes longer. We know that that using an interpreter will make it longer. So how do you start talking to the jury about that the victim will need an interpreter?
first, I think the whole reason for having interpretation is so that someone can ensure that their rights are protected. And so using an interpreter as in a court proceeding, either for the defendant or for the victim, actually doesn't stem from giving something that they don't deserve, which kind of goes to the Elliot's example of someone being reimbursed by the insurance company, but it's something that they have a right to. It's something that justice requires. And so the first thing that you want to do is present it in that way. Justice requires that people are allowed to express themselves equally in a courtroom. And if they don't speak the language, they are allowed to use an interpreter. But when thinking about interpreters, to kind of get away from that bias against interpreters, try to come up with other examples of interpreters. And the example that I would do is I'd start with the example of a deaf interpreter. That someone who's can't hear or may not be able to speak needs the assistance of an interpreter to be able to fully engage in that process. And if are there any jurors who have an issue with that? And then going into you're going to hear the evidence. When our victim speaks, our victim is going to need to use an interpreter. Is there anyone that's going to have an issue with that? And then talk to them, making sure that they understand that they will be listening to, watching the body language of the particular witness, but listening to the words of the interpreter. So you're explaining to them the process of the interpretation. And that helps the jury to understand, number one, the reason for using the interpreter, the justice behind it, and in the process. I have some more questions. Let's see. Peggy Caldwell says that they provide training for interpreters and only certified court interpreters work with jurors. And Peggy is in New Mexico. Julia says, what kind of questions help to uncover whether jurors may be able to understand the potential for victims to be unwilling co-participants in an abuser's bad conduct or crimes. And that would be actually goes along with Jane's response. And then finally, Jane's going to talk about that a little bit. And then in Seattle, one of my, Cecilia Olson says, in Seattle, one of my DD victims got an invitation to go to court and participate as a juror. She doesn't speak English and does not have legal papers in this country. Why did that happen? That's probably based on the pool. If she has a driver's license, sometimes driver's license data is used to identify jurors for jury panels. And it's not necessarily a problem because the preliminary questions that are asked as part of jury selection would actually eliminate her as a juror. That's all for me.
Yeah, Charlotte, that happens a lot, I think, in DC also, because they don't simply go off of the rolls of registered voters and so on. They want to try to get as diverse of a panel as they can, and so they do exactly what you just said. They go off of DMV and so on, and all kinds of other lists. They bring in all kinds of other, all kinds of government lists and people who have different government services to bring them in. So I think that's what you said is exactly right, Charlotte.
Yeah. So this question on the screen and the one that was also asked by Julia is like, how do you start kind of having the conversation about those bad facts, right? We know we don't want to hide from them, but how do we start having the conversation? And some of the bad facts are going to just be managing expectations and educating as far as, why a victim would maybe have been uncooperative at one point, Or you might have a more challenging piece, which is that your victim has some amount of perceived complicity or culpability in criminal acts. And of course, having prosecuted human trafficking, that was something I had to deal with in all of my cases, because not only are victims of trafficking, I'll talk about sex trafficking in particular, they're going to have criminal histories from everything. We should expect that there are probably going to be prostitution arrests. There's probably going to be some substance use issues, some theft, and all of that is directly related to them being trafficking victims. And so that's something that needs to be addressed. I am very happy to report that due to some really great work, more and more folks are familiar with domestic violence dynamics, working on the sexual assault dynamics, and human trafficking dynamics. So we can leverage the folks that are on our jurors that do have some insight into these things, whether it be folks that sometimes they will have experienced victimization themselves, or they'll know of a colleague or a friend. And Charlotte talked about how we can really leverage that lived experience within our fellow jurors. But we can also think about who might on the panel have some preliminary knowledge. I had a jury panel on a trafficking case where it was one of I'm sure you guys, prosecutors out there know, it was a jury that happened to be pulled right at sort of summer break. And so we had a ton of college students that had returned home for the summer and then were getting their jury summons. So we had a younger than usual panel. And it ended up being really fantastic because a lot of these students that were present had been learning about trafficking in college. And so a lot of them had more knowledge than I had expected. And so it was really easy for us to have that conversation that there are going to be, that victims of trafficking are exploited and forced. And some of that is going to lead to some criminality. And it might initially appear that they're complicit in that criminality. And we're going to have to talk about that. So that's one way to do it. I also think that some of these things we're going to maybe touch on in jury selection, but we don't have the capacity to really do the education that we want to. So I'm going to plug another NUOP resource, which is about the use of expert witnesses. Because the use of expert witnesses, and I want to say, Charla, you were on that call. And yes, I know you
Yes.
you did a great job, because we can't do everything in voir dire. So I think when we start introducing some subjects at voir dire, manage a little bit of expectations, and then really on certain topics, we're going to need to do some more in-depth education, and then use of an expert witness in that regard is going to really help us. But then again, that comes with the concern that we're maybe need to talk about the fact that we're going to have experts in our voir dire.
Thanks, Jane. From the list, I'm unable to see it, but I'll ask Jane or Charlotte or Elliot if you want to look at from the questions that were submitted. Is there one that we didn't get to answer during the webinar from the pre-submitted questions that you think we want to answer right now?
Looking at question number 8, what questions do you feel are the most effective in a domestic violence, sexual assault voir dire? There are 2 great resources. Our resource that we provided on voir dire in domestic violence cases, voir dire in immigrant cases involving immigrants, has some basic domestic violence questions, and then Sarah Buell with the University of Texas also has a great list of voir dire and domestic violence case questions that can be very helpful. Domestic violence and sexual assault cases that can be very helpful.
Then we do have the other question about the expert witnesses and if that's upcoming or previous. And that was, I believe that was a roundtable, and we do have the recording of it available. It should be on our new app YouTube channel. And so I'll go ahead as a follow-up to this, everyone that registered, I'll go ahead and send you a link to that discussion because I think the two go hand in hand. Well, with that, if you have more questions, if something comes up, we're here to support you. This is how you can reach out to NUAP. You can call us up at 202-274-4457, or you can email us at nuap.wcl.american.edu with your questions. We'll connect you to the expert that will be able to assist you with that, or if something that we can handle in-house, but we'll provide resources for law or research, anything that we could do to support your work. Equitas is also a great resource, Jane. You shared the information there on how you can find a resource on expert testimony in one of the webinars that Equitas provides, and there's the link there in the chat box.
Yeah, I just really encourage you guys doing this work. I have sort of talked to prosecutors who've been successful, and I said, what do you think, is the key to success? And most of them will tell me voir dire and expert witness. So that combination is the key. And I know it's not possible to do in every single case. So you've got to, pick your battles a little bit, but lots of wonderful experts out there. Equitas saves expert transcripts, so we can share those with you. We work with a cadre of experts that have experience testifying. So really take advantage of NUAP and Equitas's free resources. That's what we're saying. And then we'll connect you with people like Elliot and Charla as well.
We're happy to help.
So with that, I want to thank the panel of experts. Thank you for sharing that with us. And thank you everyone who joined us with your thoughtful questions and for the incredible work that you're doing. And thank you to the council. And with that, I'll let Jane and Charla and Elliot have the last words. So thank you, everyone.
Thanks, guys.
Thanks, guys. Really, thanks for all the work you do. This is really challenging work, and now we even more so challenging. So please allow us to support it in any way that we can. Take care.
I concur.
Be safe, everybody. Take care.
Happy fall, y'all.